Nicholas Stevens, on the 2nd of March 2026, a jury was impanelled and you pleaded not guilty to 13 charges of obtaining financial advantage by deception and 1 charge of using a false document. Originally, there were also theft charges on the indictment as alternatives to some of the deception charges, though these were later the subject of directed verdicts of not guilty. On the 30th of March 2026, the jury returned a verdict of not guilty on charge 1, but guilty on each of the other charges of obtaining financial advantage by deception and the charge of using a false document. As a consequence, you must now be sentenced for 12 charges of obtaining financial advantage by deception and the charge of using a false document. Each charge carries a maximum penalty of 10 years imprisonment. Briefly, the jury found you guilty of falsely representing to a series of families in the Mildura area that you would deliver and install a legally compliant swimming pool. The jury was told that they had to answer this question: has the prosecution proved beyond reasonable doubt that at the time of making a representation that you would deliver and install a legally compliant swimming pool with the relevant council permits, you knew that the representation was false or was probably false when you made it? In relation to each charge, except charge 1, the jury found beyond reasonable doubt that in each case you made a representation to the pool customers that you would deliver and install a legally compliant pool with the relevant council permits, and that when you did so, you knew this representation was false or probably false. By way of background, there are prerequisites for obtaining a council permit for the installation of a swimming pool. For domestic building works with a value of more than $10,000, as each project was in this case, the works require a major domestic building contract. The work must be done, or at least overseen, by a registered builder. Contracts with a value of over $16,000, as each was in this case, must also be covered by domestic building insurance. All these things need to be in place before a council permit can be issued for the pool. If the pool is installed without a permit, the local council has power to issue a stop work notice. You were not registered as a builder at any point during the charged period. There were no permit applications lodged for any of the subject pools with the Mildura Council. You gave evidence at your trial that you held a belief that an arrangement you had with a builder in Melbourne called Bricol, that you'd previously used to auspice the legal arrangements for pools you'd installed in Mildura, was still on foot. By its verdicts, the jury must have rejected that evidence. So while it is clear that at one time you paid a fee for Bricol, about $1,500 per permit, to document your earlier projects, by the time of charge 2 on 9 March 2017, you knew that there was no current arrangement with Bricol or that that was probably the case. Brian McDonnell, a registered builder and director of Bricol, gave evidence at trial about the arrangements that his company had previously had with you, and that at a certain point you stopped contacting Bricol, and that he had no knowledge of the arrangements for any of the pool customers named in the indictment. After the arrangement with Bricol ceased, you started taking deposit money for swimming pool projects into your own bank account. I turn briefly to the specific circumstances of each family's experience, turning first to Ms. Julie Martin in relation to charges 2 and 3. On 9 and 15 March 2017, you accepted $3,500 and $20,000 respectively to install a legally compliant swimming pool at the Martins' house. You provided a quote on your own letterhead. You represented to the Martins that the works would be legally compliant with the relevant permits. The works were to cost just over $30,000. You installed a swimming pool, but it was never connected to a pump or water. There was never any permit granted, nor was an application for one ever made. On 25th of May 2017, an inspector from the Mildura Council intervened and put a stop work order on the site. You ultimately went back and removed the pool shell you had installed at the Martins. I return to what happened to that pool shell later. The jury found you not guilty of charge 1 in relation to the Martins pool. I infer that they held some doubt about your state of mind about the previous arrangements with Bricol at that time, but not thereafter. Notwithstanding the council's stop work order on account of the work happening without a permit, you entered into another arrangement with another family. Turning now to the Powers, charges 4 and 5. You negotiated with the Power family in May, and on 27 June 2017 and 22nd September 2017, you accepted $3,300 and $25,533 by way of payment for upcoming work. A pool shell was delivered in early December. You made representations throughout this period that a permit was being applied for, but made excuses when the customer requested to see the documentation. When Ms. Power contacted a regional building consultant and Mildura Council herself to inquire about her permit application, she was told no such application was on foot. You continued to tell her that you just needed to, quote, fix one thing on the permit. You eventually stopped replying to Ms. Power's calls and messages. By February 2018, the council issued a stop work notice. When the customer engaged a building surveyor to check the works, she was told that there was no proof of you being a registered building practitioner. Turning now to the Knights, charges 6 and 7. In August 2017, Ben and Kerry Knight contacted you. They had an above-ground pool, but wanted an in-ground pool installed. You initially told them that they did not need a permit as they already had an existing pool. In fact, they needed a demolition permit as well as a new permit for an in-ground pool. You gave evidence at trial that you had telephoned the Mildura Council to ask if another permit was needed, given there was already an above-ground pool on site, and were told that a permit was not required. There was evidence from the council at trial that any advice given by the council would have been that 2 permits were required. I infer that the jury rejected your evidence about your call to Mildura Council. On 16 October 2017 and 13 November 2017, you obtained $3,300 and $30,483 from the Knights as the result of your representations to them that you would install a properly permitted swimming pool. You commenced some work on the Knights pool but never applied for a permit. Even though you had sent the Knights an invoice for the supply of a pool shell and they had transferred the money, when they contacted the pool supply company directly, they were told that no payment had been made. After many delays and your promises to the Knights went unfulfilled, Ms. Knight went to the police to report what had happened. On 31 January 2018, you refunded the Knights $10,000 of their money. At no stage did you apply for a permit for the Knights pool. Turning now to Tina and Rod Charman, charges 9 and 10. In October 2017, you quoted the Charmans $27,000 to install a pool. You sent them an invoice on which the figure had changed to $36,500. You followed up, requesting proof of payment so that the pool could be released from the supplier. They paid you a deposit of $3,000 on the 6th of October 2024 and a further $24,075 on the 16th of November 2027. You dug a hole in the Charmans' yard, and after a storm filled the hole with water, you told them it would have to dry out before the pool could be installed. You did some work on the 8th of January 2018. You promised to return soon. Later, you told them you would refund their money. You never did. Apart from digging a hole and fixing a stormwater pipe, there was no meaningful work completed on the project. There was never any kind of permit for the work, nor any application made. Turning now to Peter and Gemma Lindsay in relation to charges 12 and 13. Peter and Gemma Lindsay were in contact with you during October. They wanted a pool by Christmas. On 31 October 2017, you accepted $3,300 from them as a deposit, and on 24 November 2017, you accepted $23,306. Delays and excuses followed. In January, you offered to refund their money. You sent a message saying funds would be cleared on the Wednesday night. They never received any money back. You never did any work at their property. No permit was ever applied for. Turning now to the Burns, charges 15 and 16. In late October, you spoke to David Burns, who you knew from the local football club, about installing a pool. On 30 October, you accepted a $3,300 deposit from the Burnses, and on 27 and 28 November 2017, the Burnses paid you a further $25,000. You went and did excavation work on the 10th of January 2018. A pool shell appeared on 16 January 2018, but Mr. Burns noticed it looked cracked and second-hand. After Mr. Burns's wife contacted the council about the permit and was told there was no permit, the council issued a stop work order on the 18th of January 2018. It became clear that the pool you had installed at the Martins' house, and which had been removed after the council stop work order on the 25th of May 2017, had been delivered to the Burns' property, which was why it looked used. Throughout these events, you were a registered dealer for Leisure Pools, who manufactured the pool shells in Queensland. There were delivery arrangements in place, but the company had a policy of not releasing a pool for delivery until it had been fully paid for. On 7 December 2017, you sent a bank transfer receipt to Leisure Pools in order to obtain the delivery of a pool. The receipt purported to be evidence of a transfer of $15,549.62 to Leisure Pools. However, no such funds were received by them, and it is clear that an earlier banking receipt sent in relation to a different delivery had the date changed and then resent. This was the basis of the use false document charge. The jury rejected your explanation in your evidence to the effect that you did not send the email attaching the receipt. I've summarised each family's experience of paying for a pool with permits and not getting one. In each case, the witnesses spoke of their making inquiries with you, your reassurance to them that the permit applications were on foot, your making excuses about why the work was late or not occurring, and your eventual silence and disappearance. There was never any application for a permit for any of the pools, nor were there documents that were the prerequisites for getting a permit, a building contract, insurance, or oversight by a registered builder. In each case, the jury accepted that at the time you were paid money by the pool customers, you knew that your representations that there were or would be appropriate permits in place were false or was probably false. It is here, in the making of those false representations, that your criminal responsibility resides. Turning now to your personal circumstances. You're now 46 years of age. You were born in Melbourne. You're one of 4 children born to your parents, who would later separate. You had a career as a professional AFL player. You played for Port Adelaide and for Carlton. You coached AFL in Richmond and in the regions, and in the South Australian League at Glenelg. Your playing career was cut short when, in 2009, you were advised, after a neck fracture, that if you continued to play, you risked permanent spinal injury. You later qualified as a landscape gardener. You had a relationship with a woman, and from that relationship became the father to a daughter, now 3 years old. You're now separated from her mother, but have had substantial caring duties for your daughter prior to your remand. From 2017 to 2018, you were the sole director of NJS Excavation and Landscaping. You have, more recently, formed a new relationship with another woman of a duration of approximately 1 year. Your new partner wrote a character reference for your plea. Your father lives on a property near Mansfield and has significant heart and other health problems. You assist him with farming work from time to time. You have a brief criminal history, though not one involving fraud or deception. In 2015, you were found guilty of the persistent contravention of a family violence intervention order, intentionally causing injury, common law assault, and making threats to inflict serious injury and to kill. The victim was your then domestic partner, and you served 6 months imprisonment, half of which was suspended for a year. You have no fraud or deception offences in your prior history. You have one subsequent offence for breaching an intervention order, again in relation to your former partner. The conduct was the sending of messages. Your case has, on account of your status as an AFL player, attracted significant media attention. This has caused you to receive receive additional attention from other inmates in custody, and you've been separated due to safety concerns when the case is in the public eye. Turning now to the submissions put on your plea by your counsel. Mr. Stavros, who appeared for you at trial and on your plea, submitted that you have demonstrated a commitment to rehabilitation and that you have certain employment upon release. Mr. Bo Knowles of Knowles Cranes wrote a reference to that effect. Mr. Stavros made submissions about your over-reliance on third-party advice. This submission, as I said at the plea, traverses the jury's verdicts. The jury must have been taken to have rejected your evidence as to you believing you were engaging an external building surveyor and registered builder to take care of the permit documentation. I note that the building surveyor, previous builders and the council gave evidence at trial that did not corroborate your evidence. Mr. Stavros submitted that the delay in bringing your case to conclusion was extraordinary. You were charged on 11 April 2018, and it was not until the 30th of March 2026 that the jury's verdicts were delivered. Throughout this time it was submitted, your case has received media attention, and the consequent additional pressure it was submitted has been punitive. Mr. Stavros submitted that the extraordinary delay caused the case to weigh heavily on you. Initially, it was said that you had not reoffended during this time. However, the offence you committed on the 6th of February 2025 later came to light. Your barrister submitted that your rehabilitation should be prioritised and that you should be allowed to return to the community without the imposition of a custodial sentence. Mr. Stavros referred to the cases of DPP and Dipia Domenico and DPP and O'Brien as broadly comparable cases involving similar charges. He submitted that you have the support of your father, new partner, and caring responsibilities for your daughter, which in combination with steady employment make your prospects for rehabilitation good. I also received a signed character reference from Mr. Malouf, former CEO of Carlton Football Club, who recalls you conducting yourself professionally in that context. I also received a letter from your current treating psychologist confirming that you are once again undertaking weekly psychological treatment while in custody. Mr. Stavros submitted that weighing each of the matters in this case allowed me to conclude that I could impose a sentence that it did not involve your further immediate incarceration. Turning now to the submissions advanced on behalf of the prosecution. Ms. Stokes, who appeared for the prosecution, submitted that delay was a relevant feature of the mitigation of your sentence. She submitted that your family's support is a feature of your prospects for rehabilitation. The prosecution took issue with matters in a psychological report, reliance on which was subsequently withdrawn by your counsel. The prosecution acknowledged the consistent media interest but did not concede that that was anything about that was consequential for the sentence. Ms. Stokes argued that the two proffered cases were distinguishable from yours, noting in particular that they were both guilty pleas, that in both cases substantial sums were repaid by the offender, among other features. Ms. Stokes submitted that a community correction order would be an inadequate disposition, and one that would be made in the absence of any specific treatment issues. Ms. Stokes submitted that I should impose a term of imprisonment with a head sentence and a non-parole period. The prosecution tendered 5 victim impact statements to assist me in the assessment of the consequences for your victims that I will take into account on this sentence and to which I will return. I pause here to note that you have, through your counsel, indicated that you will consent to the making of compensation orders for some of your victims. I turn now to my consideration of these submissions. According to the jury's verdicts, your representations that the pools would be properly permitted, made at or before the time the pool customers transferred money to you, were known by you to be false or probably false. You made these representations repeatedly over a period of months from March to November 2017. It is important to remember, as the jury was told repeatedly, this is not a case of a breach of contract or about your failure to install swimming pools. The heart of your culpability lies in your false representations to the pool customers about the legal documentation for their projects. Without those representations, they would never have transferred their money to you. I will be astute to the danger of sentencing you for your failure to install the pools, or for stringing your customers along after you receive the money, or for leaving them with nothing except a hole in the back garden, and in some cases a big debt, when, as I've said, your culpability arose before any difficulties arose with the actual building work. Your culpability arises out of what you said, either expressly or by implication, or both, in the conversations you had in your customers' kitchens and living rooms, after which they transferred significant sums of money to you. What followed your false representations does, though, form part of the context for your offending. Time after time, the customers gave you the benefit of the doubt. They asked to see the documentation. You gave them false reassurance. You exploited the kind of small city trust that binds a regional community. Everyone took you at your word. They did not insist on paperwork early on, and you exploited that goodwill. It is tempting to see your building practice as beset by competence issues and poor paperwork systems. However, you were relatively adept at making contact with new pool customers, arranging quotes, and facilitating the receipt of significant sums of money from them. The overall quantum of your deceptions was $168,000. Taking into account the $10,000 you repaid the Knight family, the overall loss to the customers was $158,000. In May 2017, there was a council stop work order at the Martins property. In June, August, October and November that year, you were still taking people's deposits. You did this even when you knew the real consequences of your false representations was for the council to arrive and to stop the work. Your culpability grows as time goes on. You sent a falsified document to the pool supply company with the intention of inducing them to deliver a pool shell that had not been paid for. The people you deceived were trusting and in many cases could not afford to make amends. The situation caused them ongoing agitation and distress as your deception of them slowly dawned. In one case, the pool customers were retirees who could little afford to service the loan that they had taken out to fund the work that you never did. They each wasted time and energy solving the problem of unfinished work. There was both financial hardship and humiliation. Throughout, several of them had unfinished work in their gardens as a constant reminder in their private home of your deception of them. Some spoke of the despair they felt when they found themselves having to explain the absence of a long-promised pool to small children in a hot Mildura Christmas. You pleaded not guilty and chose to have your case determined by a jury, and that was your right. I am very troubled by the feature of delay in this case, and it warrants some explanation. You were interviewed in April 2018. The first chapter of delay in your case was caused by the pandemic. However, it did not stop there. In 2024, there were attempts to impanel a jury in Mildura, but the number of excuses decimated the jury panel as so many people were somehow connected to the witnesses in the case. The informant then became unwell and the case was transferred to Melbourne. In Melbourne, another judge of this court impanelled a jury, heard much of the evidence, but unexpectedly had to withdraw after a conflict was discovered. It was another year before the case could be relisted, but the trouble was not over. 2 juries were impanelled more recently through lack of readiness with previously recorded evidence and a further delay caused by the jury being inadvertently shown your prior criminal history in a prosecution exhibit. The consequences of all that is that I accept that the delay in this case was not caused by you, but imposed on you by a series of historical and procedural failings which, when taken together, have caused you to labour under the cloud of this case for over 8 years from the date you were first interviewed. This is a very significant feature that I will apply in the mitigation of your sentence. It has been punitive, and with one exception, you have not reoffended. I acknowledge that there has been media attention in your case, but it was not argued that it stood alone as some feature of mitigation. Rather, as I understood it, it was a feature adding to the burden of the delay, and I accept that, as I've already described the delay, as extraordinary. I assess your prospects of rehabilitation as generally good, tempered, I should say, a little by your return to court for other forms of offending. I accept that you have the support of a family, a partner, good work prospects, and you have a commitment to the care of your daughter. You must have known your customers could ill afford to fund your empty promises. While I do not make findings about an absence of remorse, there is some role for specific deterrence in the circumstances. There is also a role for general deterrence. People who might wish to exploit trusting people and take their money need to appreciate what awaits them. I've taken into account what the victims said in their statements and what they said in their evidence about what happened. More broadly, beyond their specific experiences, what you did had a corrosive effect on the currency of goodwill and trust that does so much good in a community, especially in a small one. I was given some sentences said to be alike to yours on the plea. They can both be distinguished on the basis of there being pleas of guilty and substantial repayment. They lack, though, the feature of delay your case has. I've had regard to the broad sentencing landscape in which your case falls. This is not a straightforward sentencing task. Taking into account the repeated nature of your conduct, the amount of money you obtained, the consequences for your victim, and the enduring period over which your offending unfolded, I was inclined towards a head sentence with a non-parole period. However, pulling in the other direction is the very lengthy delay and your decent prospects of rehabilitation. In the end, I have decided to impose a combination of imprisonment with a community correction order. Nicholas Stevens, I'm imposing an aggregate sentence of 9 months imprisonment, after which you will be released and subject to a community correction order. The duration of the community correction order will be 24 months. You'll be required to perform unpaid community work. I have ordered this as an additional component of punishment beyond that of the time that you will serve in custody. I'm imposing an aggregate sentence of imprisonment with a community correction order on all sentences because there are many individual charges and they are part of a series of offences on very similar facts. I do not lose sight of the number of individual victims. I impose this aggregate sentence because it simplifies the sentencing task and this sentence. On charges 2, 3, 4, 5, 6, 7, 9, 10, 12, 13, 15, 16 and 18, you are convicted and sentenced to a term of imprisonment of 9 months, followed by a community correction order of 2 years duration. I pause here to note that I had you assessed for a CCO, you were found suitable and a mental health condition was recommended. I'm now going to read you the conditions of the community correction order, which will be for the duration of 24 months. And at the end, I will be asking you to indicate your consent to the making of that order. You must report to the Ringwood Community Corrections Service within 2 days of your release from the custodial portion of your sentence. You will first be subject to the standard conditions of a CCO. That means, importantly, you must not commit any other offences that are punishable by imprisonment during the 24-month period. I will be clear about this. If you commit another offence, you'll be brought back to court before me and resentenced for these offences. Absent very powerful reasons, you should expect that that would involve your imprisonment. You are required to advise your supervisor in the corrections office of any change of address where you're living or working, and you must do so within 2 clear working days of doing so. It is a term of all community correction orders that you must submit to visits as directed, and you must obey all of the instructions and directions of a community correction officer. You're not able to leave the state of Victoria without their prior permission, and that is for the entire 24 months. The special conditions that I will attach to the order are as follows. You are required to submit to mental health assessment and treatment. I require you to perform 120 hours of unpaid community work over the term of this order, but pursuant to section 48 C A of the Sentencing Act, I direct that time spent in treatment and rehabilitation programs be credited towards those hours. I also require you to participate in judicial monitoring. I will require you to appear before me 3 months after the commencement of your CCO, which will be on the 25th of March 2027 at 9:30 a.m. By that time, I will have a report which I trust will confirm your early engagement with that order. You have consented to the making of orders for compensation to each identified victim, less the sums repaid. Those orders will be made as soon as practicable and will attempt to recompense the victims for their losses. Finally, I declare that you have already served 78 days by way of pre-sentence detention.